look forward to having our annual talk of what do we have to worry about for the next year when it comes to regulation. And as usual in this talk, I know we have maybe a relatively large room here, but I want this to be as informal as possible. And if you have questions as we go through this, the time to ask those is when I'm going through the materials. And again, I'm glad to take questions as we go. You have a handout. If you don't, raise your hand and we'll get you one. We have a handout of the slides I'm going to be covering. We have a person over there that needs one. And Kent, would you mind grabbing it out? Thank you. Again, that you have a hard copy of the slides I'll be covering, and there's 57 of them. I'm not going to pretend that in an hour we could cover 57 slides in any amount of detail. Some of those we will spend a great amount of time on. Many of them I'll mention. I may skip over some of them. Doesn't mean they aren't important. It just means we don't have time to cover that, and I'll leave that to your reading. And if, as with all the talks I give, if you have questions, again, bring them up as we go. If you have additional questions that we don't have time for during the talk, and if you want to talk to me individually, I'll be around here afterwards. I'll be glad to talk to you then. Or if after you leave the show and you're reading through the slides, as I know you all will, read those diligently, feel free to give me a call if you have a question. Be glad to. I want to make sure that we're putting out correct information. If it doesn't make sense to you, the time to ask is now or when you're going through it, and we'll be glad to go through your individual situation. In general today, again, there's 57 slides there. They are numbered in the lower right-hand corner, so I will, as we're going through it, I will often refer to a certain slide and say, circle this, mark that, do this, whatever. In general, if you just want to leaf through them, I know it always helps me to get an overview of what we may be talking about. The first couple slides, first several are on nuisance cases. And Kent made an incorrect statement when he introduced me, and he said we will be talking about the recent nuisance cases. The reason that is incorrect is, good news, folks, there aren't any. All right? So, I, of course, say that tongue-in-cheek with Kent making an incorrect statement because we build it as recent nuisance cases. But again, for the swine industry, for livestock in general, that is very good news. And we'll talk about that for a few minutes. Then we're going to spend a fair amount of time talking about something that I hope you don't have to worry about as confinement livestock producers anyway for several years, and that is EPA, NPDES permits, DNR work plan, DNR inspections as required by EPA. We're going to spend a fair amount of time on that. You've been reading and hearing about that in the media, and we will cover that. That takes us, as I'm looking at our slides, that takes us clear on over to page 5. We'll talk a little bit about composting as it relates to that, and then as it relates to these DNR inspections coming up as required by EPA. We get on over on page 6. I'm just telling you right now, slide 35 is one I'm going to spend some time on. Probably could have had several slides in there about animal unit and animal weight capacity, how to calculate that, and what it really means to your operation, and some of the pitfalls of the animal unit capacity calculations and requirements. Then we're going to go over on page 7, talk about the master matrix for a little bit, some of the issues we've seen in the last year with producers who have either had to comply with their matrix, obviously, or permit applications. And then depending on the time left on page 7, over on page 8, we'll talk about manure application during the winter. Some EPA air emissions reporting issues on page 8. And then page 9 and 10, don't know how much time we'll have to get to those, but one of the things we've been dealing with, and a topic I haven't covered in past years, slides 49 and 50, they're at the top, water priority allocation. You don't need an attorney to stand up here and tell you it's been dry, and it's still dry. And are we going to run into issues with allocating water under the Iowa Code? We have an Iowa Code section that's been there since, I believe, the the 80s, never really been used, but we have a system in place in Iowa to allocate water if necessary. Then the last item on page 9, EPA on-farm oil spill prevention plans. I've talked about that for the past few years. Probably won't spend much time on that, but it's not a livestock issue, but it is something, as we've discussed, these updated on-farm oil spill prevention plans. The updates are due May 2013. When we stood here a year ago, I said, oh, that's May 2013. That's a ways off. Well, guess what's only a few months away. So, with that, should we get started? Any questions before we start? How about that? All right, here we go. We're going to start with the slide on if what I tell you today is not in-depth enough and you really want to dig into this, we have on the Iowa Pork Producer Association website, it's on the bottom of page 2 there, the Environmental Regulations Handbook. It is pretty detailed. We've worked on that for several years, updated it. Always needs updating, and I need to get to that now. It really does get into the details, and sometimes maybe more detail than most people want. But go to that and see if that helps you. If you have an in-depth question, you can search it, do a word search, whatever. Again, it's online on the Iowa Pork Producer Association website. Kent, I know I'm going to put you on the spot every now and then, along with some other people here. I know, I work with Kent quite a bit through the coalition to help producers. Kent and the coalition do an excellent job of getting out there on the farm, working with you, the producer, to get these regulations figured out either before you build or whatever situation you have occurring. I know, Kent, the handbook is something you and I, you'll look at it and you'll say, hey, where's this at? And I try and update things. It is pretty detailed, right, Kent? And again, we don't have codes. Kent noted how, there's a lot there. We don't have code sections, citations. If you're needing to get to the regulations, if you're a consultant and need a regulation number to work with DNR or something, as you're going through that, let me know. I've often thought about putting the citations to the regulations in there, but I just think it would make it more cumbersome, more legal in nature. We try to keep it as down to earth as we can for people to use in their own operations. I don't know if we accomplish that all the time, but again, it is very detailed. All right, with that, nuisance cases. I already alluded to this. Slide 3, there in 2009, 2010, 2011, and 2012, to my knowledge, in the state of Iowa, no nuisance cases went to trial where it was a claim of a nuisance, odor, whatever it is, against an agricultural operation. No cases went to trial. Here a few years ago, 10 years ago, 2003, if I remember right, we spent about half of this talk on nuisance cases, what was going on, what you needed to be doing, and I think we had about 13 cases on file at that time. So, knock on wood, I guess it's a very good situation in Iowa right now. Some other states aren't that lucky. Illinois has several on file. Missouri had a bunch on file, as many of you know. And I hope that means we're doing things right here. Obviously, something is being done right. Keep it up. We'll talk a little bit about what I think we should keep doing. In addition to none having went to trial, right now, and again, I'll give my standard disclaimer, there is no searchable database where I can tell you for sure that there are no cases on file right now. But to my knowledge, and I check with other attorneys who are in this business with me, to my knowledge, there are no cases currently pending in the Iowa courts. A couple cases were just settled, and these cases, again, I'm talking about nuisance cases against agricultural operations in Iowa. Folks, I've been doing this since, got out of law school in 91, been working in this area of the law since then, and I can't say this for sure, but I think this is the first time I can say that there are none pending, none on file. Now, we have some mediation cases out there, and by mediation I mean before a case can go to trial, it must go through mediation. That's required by Iowa law. And there have been cases that have went through mediation. I think there are some that are scheduled now. Those aren't reported, but that doesn't mean those cases have been filed in court. Okay? All right. I still want to talk about the steps to hopefully avoid a nuisance lawsuit. And I think these factors, I think this is what people are following. The reason we're having pretty good luck in the state right now. Don't take our good luck for cases not being on file for granted. Let's not get complacent. Keep doing these things in your operations. If you're locating a new operation, and I know Kent and the coalition work with producers very closely on this. Really, when it comes to odor nuisance, there is no substitute. Well, there is let me say it this way. I don't think there's an absolute substitute for a good separation distance. The further, the better. There are things you can do to account for the fact that you don't have as much separation distance as you might like. And that's what these things are listed below. But you start with get the best separation distance you can. Pay attention to prevailing winds. You know, all separation distances are not created equal. The prevailing winds in Iowa are primarily, the prevailing winds are south to even a little bit southeast, but primarily right out of the south. Many people think southwest, but that's not what the records show. So pay attention to that when you're locating an operation and you're looking at separation distances. Tree buffers, again, all the Iowa Pork Producers Association and the coalition and other groups work with producers on planting trees. Tree buffers, science shows, help reduce odor, mix up the wind patterns, and all of that, your shelter belts, etc. Tree buffers are very important. Biofilters in certain situations should be looked at. Not all. Some sites don't need it, depending on these other factors. And there are various types of biofilters out there. I'm sure there are people upstairs who can give you information on biofilters. If your operation, again, has some other factors that may be causing you a problem in with your neighbors and your separation distance may not be as great or something, then take a look at biofilters. The fourth bullet point there is one, I harp on this every year, and I know others do too, but clean pigs in buildings. Don't sell yourself short for taking good care of those pigs, for spending the money on a good ventilation system. That means whatever that system is, because when pigs are comfortable, you know this better than I, when they're comfortable, when the ventilation is working, the manure goes down in the pit. It doesn't get covered all over the pig because that pig is uncomfortable. When that pig's uncomfortable and they're covered with manure to try and stay cool, that creates more odor. And again, when I get involved in these cases as an attorney, I try and focus on, with the producer, again, one of the things we do to reduce odor, we have a good ventilation system and therefore clean pigs. Manure treatments and additives, there are a lot of products out there, and I'll leave those to you. It's something that you should take a look at in certain situations. And then just plain timing of manure agitation and application. Work with your neighbors about when it's done. Let them know when you're going to do it. If it works in your situation, in your neighborhood, just try to work with your neighbors knowing that you have to pump those pits sometime. Let them know when you're going to do it. And if they can tell you, hey, I've got something planned that weekend, if they'll be reasonable, I think you'll try and be reasonable, and hopefully it all works out. The next slide, slide 5, insurance. Again, I talk about this every year. If you, in your operation, have a concern about, or just plain want to be protected, the standard farm liability policies, and I'm talking just standard, and there are variations, but as a general rule, standard farm liability policies do not cover protection for a nuisance lawsuit. You can buy the coverage. There are several companies that offer it, and I think we have vendors here that are offering it. Take a look at it. If it fits with your operation, it can provide the coverage you need in case you are sued for nuisance, and it provides coverage, as we have there on the slide, coverage for claims. So if you're sued and you have to pay money either through a settlement or a court judgment for a nuisance claim, the policy will cover it up to the policy limits. It also pays for people like me. and that is the attorney to defend you. And that, in many cases, and this is not a public service announcement, but in many cases, that can be substantial. How's that? All right? And again, for many operations, a very important part of their risk management. Now, the last bullet point there on the slide, and again, this is not a public service announcement for attorneys either, but read that coverage carefully. If you're, whichever company you're buying it from, we've seen some cases, primarily in the contract growers insurance, which I'm not going to talk about here this morning in the context of environmental regulation, but if you're a contract grower and you're feeding someone else's pigs, you should look into coverage for if those pigs die in your buildings due to suffocation or a catastrophic event. You want to make sure you're covered for that, and that's not what I'm talking about here, but it's kind of in all the same area of insurance, of course. Read those coverages very, very carefully and make sure that you are covered, especially if you're purchasing from a company or an agent or a broker that is not really in this business all that much but is offering this product. I'm not disparaging anyone. Just read it carefully. We have an Iowa Supreme Court case in the contract growing area, and that insurance where the producer thought they were buying coverage for it. When the pigs died from a suffocation event, they turned it in, and the company said no coverage, and it's now in the courts, and I don't know which way it's going to go. It's in front of the Iowa Supreme Court now. But if you're buying this coverage, have it reviewed very, very carefully to make sure you're getting what you think you're getting and what you want for the protection you need. Okay. All right. That's it for nuisance and insurance issues. Any questions on that? Okay. Now we're going to get into the area of environmental regulation that I mentioned. All of this is going to lead over about the next, how many pages? We are now in your slides at the bottom, page 1, slide number 6. I think it's going to take us all the way back to, about slide 30 or so. And we're going to move through some of those fairly quickly, but what we're talking about here at the end, if you look down the end of this pipe I'm going to tell you, you really don't need to do anything right now differently in your operations, I don't believe. How's that? We've got about 25 slides on this, but it's a big issue. The issue is, and you've seen it in the Des Moines Register, other media, the federal EPA has, in response to a report they issued in response to claims by environmental groups that the Iowa DNR was not adequately enforcing the Federal Clean Water Act. In response to all that, the federal EPA is proposing to DNR, the Iowa DNR, through what they call a work plan, that over the next 5 years, the Iowa DNR inspect every livestock operation in the state of Iowa, pretty close anyway, to determine if those livestock operations are discharging in violation of the Federal Clean Water Act. So, with that premise, I kind of today wanted to start at the beginning. All right, as a basic premise in Iowa law, we have either confinement operations or open feedlot operations. Most of you here probably have confinement operations. These are the deep pit hog buildings, totally roofed, pigs never get outside, at least that's the plan. And you may have outside storage, you may have a lagoon or a tank, or you may have a deep pit storage underneath that building, but a confinement building. Open feedlots, we have some hogs raised outside, of course. Those would be open feedlots. If they can get outside, it's an open feedlot. A lot of those are cattle, dairy, etc. Last bullet point on number 6, circle that. And I'm going to take this opportunity. Gene, can I introduce you right now? I guess you have no choice. I just said I'm going to. Gene Tinker, raise your hand. Gene Tinker is here from the Iowa DNR. Gene comes every year to these. And I always give Gene a call every year before I give this talk and say, okay, Gene, what's the hot topic? And we'll talk about that maybe after a while. But that last bullet point, a confinement operation cannot discharge under Iowa law, has been the law since way back when. I don't think it was ever any different in the state of Iowa. Just keep that premise in mind, because what I'm going to be talking about is what EPA is telling Iowa we need to do is inspect all these livestock operations to determine if they are discharging in violation of the Federal Clean Water Act when Iowa law says you can't discharge. Okay? Now, I wish I could end the discussion right there and say, folks, and we have ended the discussion right there in years past, but I can't do that because the Region 7 EPA is directing DNR to do this. So we'll go through all this so we know what you can expect in your operations. All right? Now I'm going to throw the term CAFO at you, and I know many of you know this. I don't mean to be too elementary, but don't get CFO, confinement operation, mixed up with CAFO, concentrated animal feeding operation. That's a federal term, and the federal term includes, I'm going to back up, the federal term includes both confinements and open feedlots. Federal law doesn't distinguish between the two, confinements and open lots. That's Iowa law. Quite frankly, I think Iowa law does a much better job of regulating those areas than federal law does. But they didn't ask me. So, and if they do, well, they know how I feel. But if they ever do suggest that we make a change, I certainly would pitch Iowa's system over the federal system. Chances of that happening are pretty darn slim, folks. All right. Slide number 7. 3 types of CAFOs. Federal law, and let's stop here a second. A lot of you have a construction permit under Iowa law. You had to get a construction permit to build if you were over a certain size, and right now that size is 2,500 head of hogs. When I talk about a discharge permit, an NPDES permit here on slide 7, I'm not talking about that construction permit. That's an Iowa law permit, and quite honestly, a very important permit. For confinements, that's usually all we've had to worry about. What I'm talking about with the NPDES permit, it's the National Pollution Discharge Elimination System. You can see why I didn't put it on the slide. It's a discharge permit. It's a 5-year permit. It's a permit that allows you to discharge. Your city municipalities have an NPDES permit that allows them to discharge in certain circumstances. Other businesses have that. Confinement operations, guess what? If you get a discharge permit, you know what that discharge permit is going to say? You can't discharge. All right. Is my feeling coming through here at all, what I think about this? Okay. But under federal law, if you're above a certain size, and we'll talk about here those in the next slides, and look at number 7, I underlined it here, circle that if you would. If you're in these categories, large CAFO, medium CAFO, designated CAFO, you must have a federal discharge permit, which DNR will issue, if the CAFO discharges pollutants to a water of the U.S. What have I been saying? Under Iowa law, the confinements can't discharge. There, I said it again. So, without an NPDES permit, under federal law, there can be no discharge. Again, what did I say? Under Iowa law, you can't discharge anyway. Okay. If you have an NPDES permit, you can discharge from greater than the 25-year, 24-hour storm event. And this is where some of these others, cattle feedlots can get these permits because they're open feedlots, etc. But you can't if you're a confinement operation because Iowa law does not allow you to discharge. All right. I think I'll say it at least 10 more times before this talk is over, folks. What is a large CAFO? Look at the third bullet point down. That's 2,500 swine, 55 pounds or more. That coincides with the Iowa law requirement to get a construction permit. But we're talking about a CAFO for the NPDES permit. 10,000 swine weighing less than 55 pounds. And then I have the other species up there also. All right. Yeah, we'll talk about combination operations in a minute. Medium CAFO. You're going to be hearing a fair amount about medium CAFOs here over the next few months, years, etc. For hog operations in confinement, I would just assume something just sounded different. Are we okay? There we go. All right. For hog operations in confinement, medium CAFO, I don't think it just doesn't come into play. But here's what it is. A medium CAFO is it's the 300 to 999 animal units, which is not a factor the federal law uses. But for cattle, it's 1-to-1. If we were going to look at them for hogs, it'd be animal units. And, okay, so it's less than 1,000 head and meet the requirements on this slide. You discharge into waters of the U.S. through a man-made ditch, flushing system, or other man-made device, or directly into the waters of the U.S. that run right through the CAFO. Well, we don't have that issue with confinements. The reason I'm spending a little time on this, folks, is if you have, let me go to the next one, combination operations. If you have a confinement hog building and an open feedlot cattle lot, or if you have hogs outside on the same site, anything within 2,500 feet, then you've got a combination operation. Then you need to pay attention to this. Or if you have a cattle yard, you need to pay attention to that medium CAFO issue. I'll be glad to spend more time on that with you individually if you'd like. The Iowa Cattlemen's Association, whom I also work with, will be spending quite a bit of time working with producers, because as we're going to talk about, those lots, those size operations, the 300 to 99 head open lots, cattle, and if you have hogs, we have to use animal units, those are going to be under some severe scrutiny from Iowa DNR as a result of the EPA work plan here in the next couple of years. Okay? But combination operations. This slide, I kind of go through a little history of how EPA rules have never distinguished, as I talk about, between confinement and open. Never have distinguished. They're all the same to them. Iowa has distinguished between them, has caused some confusion in past years. For purposes of the NPDES permit, if you have the same species in confinement and open lot, like if you have confinement cattle and open lot cattle, you have to add them together. Confinement hogs and open lot hogs have to add them together for purposes of this discharge permit. We'll talk, again, that's not really the critical issue we need to talk about here today. Here's the one I want to focus on with you folks. Slide 12. Put a check mark by this. We'll talk about, but what has the EPA been doing over the last few years? They've been chartering small planes and sending some of their folks up and doing flyovers at certain times of the year when it might be prime time, such as a snow melt in the spring or whenever, late March, early April, and they're looking for violations of the Federal Clean Water Act. When they see a confinement building there, chances are they're not going to see anything running away from that confinement building, deep pit building, etc. But if they see an open lot next to it, that comes up on their radar screen. And look at this slide is where we can get into trouble, so to speak. Under the federal and DNR rules for this federal discharge permit I'm talking about, you don't add together different species. If you have confinement hogs and open lot cattle, you don't add those two together because they're in different categories than that previous slide. With an exception, right here, slide 12. And I think this situation may be fairly common. Let's say that you have, as I have on example here, you have a hog confinement operation with more than 2,500 head, 3,000 head hog building. Then you have a small open feedlot, definition of small, I'll leave that up to you, 400 or 500 head, whatever it is. That 400 or 500 head cattle feedlot by itself would not need an NPDES permit, and if the hog building were below the 2,500 head threshold, you wouldn't add them together. But what happens when you trigger the 2,500 head threshold for the NPDES permit with one species, you just sucked everything in. A couple horses, well, I'm probably stretching it there, but okay. You then brought in that cattle open feedlot because you triggered the NPDES permit requirement with the hog building. If you have, or if you have clients that have that situation, please let them know about it and let them know they need to pay attention to that cattle feedlot. If it's discharging, then they could be in a situation, as we note here, where they could be told you need an NPDES permit. Now, if they're not discharging, then I'll leave that up to you. Okay. Gene? The question, and because Gene isn't on the mic here like I am, I'll go ahead and repeat it so it's on the tape. Gene's question was, what if you have open lot hogs and open lot cattle? Those would get added together because they're in, well, wait, I need to stop. Almost caught me there, Gene. They don't get added together for purposes of federal regulation unless one of the categories is triggered, because federal law doesn't add up between categories. See, federal law and DNR, as they implement it, those categories I'm showing, and I'll go back to the large one, you don't add between categories. So what Gene just gave me was hogs, which would be the third bullet point category, and cattle is the second bullet point category. You don't add between. But what Gene's talking about here, under Iowa law for open feedlot regulation, construction permit, right, Gene? Well, okay, but for Iowa law, you would add them together for Iowa law purposes. But for the federal law, for the NPDES permit, if they're different species and you don't trigger the NPDES permit requirement with either species, then they shouldn't be added together. But I guess I maintain, and we'll probably, all right, we'll put this under the category, I'll get back to you, because under state law, we said you add the same types of animal, if it's, well, bottom slide 8 here, don't I have that right there that says, for DNR rules, 1,000 animal units where more than one category is kept in the same type of operation. But I don't interpret that to say that applies to the NPDES requirements. Now, maybe I need to go back and look at that. But anyway. Well, but, okay. I think we may have a difference of opinion here. Okay? I'll for the hog site, what you're saying is open lot hogs and open lot cattle, right? All right. For the typical situation of confinement hogs and either outside hogs, you would add those together because they're the same species, clearly. Confinement hogs and confinement cattle, you don't add those together unless you've triggered one of the species, right? We agree on that? For state law purposes, but not for NPDES permit purposes. You don't add them together unless you've triggered one of them. If they're different species, so you're saying that DNR's position is that for large CAFO purposes, we add confinement hogs and open lot cattle, even if we haven't triggered one of the NPDES requirements? So you're saying if we have confinement hogs and confinement cattle, we'd add those together to determine if an NPDES permit is required. Okay. I'm not buying that, but anyway, we'll talk, okay? We need to get that resolved. Yes, question. The question was to determine what is one operation or two. Really? And I don't have a slide on that here. To determine what is one operation or two, federal law says they have to be adjoining. The operations have to be adjoining, okay? Iowa law actually gives us distances for what is adjacent. My understanding is, right now, EPA has said they will recognize and follow Iowa's distances unless the operation is having discharge issues, where then they'll take a look at whether it should be designated as a CAFO. But my experience has been federal EPA will follow the distances, and again, unless they see severe runoff issues from the open feedlot or something. Gene, is that what your understanding is from federal EPA? Okay. Did that answer your question? I'll say it again if it didn't, because it's important. The distances in Iowa law, we can follow those. So if you're further than the distances apart, then you're separate operations. For confinements, it's more than, if you're under 1,000 animal units, it's 1,250 feet apart. For if you're over 1,000 animal units, it's 2,500 feet apart. If you own both operations to be, or manage, to be considered separate operations. Okay? Again, EPA has been respecting those distances. I know there are some who would say they know that EPA may not, but again, in my experience, EPA said they will respect those distances. with subject to if there are severe runoff, or I shouldn't put the word severe in there. If there are runoff issues occurring, they will look at whether they should be designated as CAFOs. Okay. I hope we haven't got everybody totally confused here. Again, what I want to get at here is what we're talking. I think we're getting kind of caught in some of the minutia here of the mixed operations. And if you don't have that, you're sitting there thinking, can we move on so I can talk about what I have? But if you have a mixed operation, cattle and hogs, come see me, let's talk. Gene and I have a difference of opinion here, and maybe we get to the same place and we're just talking nuances. I don't know. I don't want to spend any more time on that. But it is these mixed animal operations are very, very important. We have a lot of family operations that use that and that have mixed both species. We want to make sure that you're in compliance, and through the coalition, through the Iowa Pork Producers Association, and DNR, we want to work with you to make sure you're in compliance. Okay? All right. Designated CAFOs, what this really boils down to is if you have a spill or runoff problems and those occur repeatedly, DNR may step in and say, look, even though you don't meet these other categories, you're having problems, we're designating you as a CAFO, and therefore you have to get an NPDES permit. And this is laid out in these slides. I'm not going to spend any more time on that. DNR evaluation on slide 15. Yes? No, what I'm saying is you don't look at the size categories, you go by what DNR, if you're having problems, they can designate you a CAFO. There are some limitations on what they can do based on size. I've got those in the slides, but in the interest of time, I think we'll move on. I do want to get to some of this other. I don't want to get caught in a lot of this and miss the big picture here. What is a discharge? I've been standing up here talking about discharge for how long, and I haven't really told you what is a discharge. Well, it's a discharge of pollutants to a water of the United States. If it gets out of your pit, is on the ground outside, but doesn't go any further, that's a violation of Iowa law because you haven't contained all the manure, but it's not a discharge under federal law because it hasn't gotten into a water of the United States. Okay? Discharges include land application. When you're knifing it in, whatever you're doing to land apply the manure, and you have a discharge, then that's a discharge that could be in violation of the Federal Clean Water Act. But ag stormwater discharges, which under federal law, that's what they call them, are exempt. We're going to get to a good spot here, folks. Bear with me. To be an ag stormwater discharge for manure application, you must have a you must apply based on a nutrient management plan specific for your operation. Your manure management plan qualifies for that. So your discharges, I'm locked up. I can't. Here we go. There we went. All right. Yes, Gene. Okay. When you said, all right, let's back up. Gene's question is, if you have a manure management plan, you're putting on manure and also commercial fertilizer. What do you mean by not claiming it? And producers do that. If they do that, it's covered then. What caused the discharge into the water? Was it the manure? Well, I think... I know your question, Gene, but you're presenting a situation that I don't think happens that often, number one. But number two, producers that do have it in their MMP get the exemption, right? All right. If they do not put in their manure management plan that they're putting on commercial fertilizer, if they don't put the correct amount down, you're trying to say they don't get the exemption for the accidental discharge. Right. Okay. I'm telling you, I think that's that for the bulk of the producers, they do put that in, and you're correct, they need to do it. I still think they get the exemption because it's got to be proven what it came from, and I think that's almost impossible to do. Your point is they aren't following a site-specific nutrient management plan. Is that your question? That could be an issue. But again, if they are putting them both in, they would be covered. And so Gene raises a good point. You got to make sure you're correct here. If you aren't putting your fertilizer in, you're opening yourself up to a question. You should, and I think, again, you have to get statements from the crop producer that how much are they going to put on. That was put in Iowa law several years ago. But this exemption, again, is for an accidental discharge. And the key is that you correct the conditions that caused it. So, and you do have a site-specific nutrient management plan, and you've applied the manure based on that. The question is if you went over the what the commercial fertilizer added to it. Now, I'm not going to get into more details there. The lawyer in me says to me that you still have some arguments you can make that you were following your site-specific nutrient management plan, and if what caused the discharge was a manure spill, then that you could still be okay. But Gene is correct. If the point is, make sure you get both your commercial fertilizer and your manure covered in your manure management plan. Make sure you get both put in and apply accordingly. Okay? All right. Accidental discharges. This is a key because many of the environmental groups would like to see you have to get an NPDES permit because you have a hose break or some other type of spill, and they believe there's a discharge, you need an NPDES permit. What the federal rule says, and this is respected by Iowa DNR, is that if you have an accidental discharge, you don't need an NPDES permit as long as you correct the conditions that caused the discharge. And we'll talk about DNR's inspection plan here in a little bit, but this is going to be one of the things they're going to be looking at. So if you've had a spill, the key in your DNR order, and when I work with people on these, or whoever you work with on these orders, including DNR, make sure you get included in the order that you have corrected those conditions and make sure you follow it. So you say, Mr. McAfee, how do I correct a condition if the hose broke? What you need to do is put in the order and put in your operating procedures that you will test hoses. If it's a commercial applicator, require the commercial applicator to regularly test hoses, do an inspection procedure to check them during manure application to make sure that you have tried to do the best you can to make sure you don't have another hose break. Had situations where people have left an agitating pump unattended while they apply manure. And then what happens? The pump moves, shoots over the edge of the lagoon, you have a spill. Put it in your procedures that you won't leave the pump unattended. That's correcting the condition that caused the spill. Okay? Proof of a discharge. I've been telling you, okay, here's what a discharge is. It's getting into the water of the U.S. How do you prove it? How does Iowa DNR or how does federal EPA prove it? Computer modeling was tried a few years ago. That by federal EPA, no, that federal EPA is not using that anymore, and I don't believe Iowa DNR ever did. I already talked about flyovers. Federal EPA will, and Gene, I asked you this, I think, a few weeks ago at the Cattlemen Convention, but to my knowledge, DNR does not use flyovers on a regular basis. You've done it maybe once or twice, you said, to count cattle in a feedlot. All right. It's on-the-ground inspections. DNR will come out and either through visual observation, and they'll take photos, or water sampling to prove if you've had a discharge from your operation. Okay? All right. Now, I'm going to move through, because it's already 10 o'clock and I have a lot of ground to cover here. I'm on slide 19. And I was going to give you a little history here on how we got here, and I'm going to move through it quickly, leave it for your reading. Federal EPA has tried several times in their regulations to go beyond an actual discharge that would require you to get this discharge permit, and it hasn't worked. The courts have struck it down twice. Okay? So July 30, 2012, I'm on slide 20. July 30 of this year, EPA issued revised regulations. And without any public comment, they didn't ask for it. They just said, finally, they have agreed after 2 federal courts ruled they were wrong. EPA has agreed a discharge. You need an NPDES permit if you're in one of these categories we talked about and you have a discharge. There are other standards they try to use, proposed to discharge, etc. got thrown out, as I note here on, and they took them out of the final rules. I note here on slide 20. So down at slide 20, circle that bottom one. The EPA CAFO rule now requires an NPDES permit if there is a discharge from a large, medium, or designated CAFO. Okay. Now we're going to step back a little bit again and get to this point of where we at with this DNR EPA work plan. In September of 2007, 3 environmental groups filed a petition, as I mentioned earlier, with the federal EPA and said, Iowa DNR is not doing their job when it comes to the federal CAFO program and for NPDES permits. And as a result of that petition, they raised like 40-some allegations of what DNR was not doing. Over the last 5 years, the Iowa legislature and the Iowa DNR and the EPC through rules have made changes, even though I and others didn't think any changes were necessary. Changes were made in the rules to make it more clear that Iowa DNR and Iowa regulations do follow the Federal Clean Water Act. Then in August 18 of 2011, the petitioners still weren't satisfied. They filed a notice of intent to sue with EPA saying you aren't making them do it. Well, they haven't done that yet, but on July 12 of this year, EPA issued its initial report. And what EPA said, here on slide 22, that EPA expects DNR to do these things, 4 bullet points here, and I think we'll just move on through this, and I'll cover this in the draft work plan because it really lays it out. EPA put that in the draft work plan of what they expect DNR to do. DNR responded to this initial report. They rebutted some of the allegations regarding enforcement actions, and they described some of the corrective actions they took. EPA invited public comment. IPPA and other groups responded, and quite honestly, we spent as much time in our comments telling EPA that even where DNR is already doing it, we didn't think their report was absolutely fair and correct to DNR, that EPA should have responded differently. I won't take your time with that. Let's get to the real heart of the matter. Bottom line is, we were not satisfied with that EPA initial report, that it mischaracterized many things that Iowa DNR does and Iowa law, but we got beyond it. October 31st was when those comments went in, and a work plan came out. I don't have a date on it here. I think it was sometime in mid-December, wasn't it, Gene? Somewhere in there. Here's the work plan. What it means is EPA is asking DNR to sign this. Can I ask you, Gene, has DNR signed it as of yet? Gene said no because the Iowa Governor's Office has not yet approved it. Is that right? We'll go through some details here, Gene. I'm going off of the one that's on the website. If there's something that has changed there, raise your hand. Dates? Okay, all right. Here's the first bullet point, number 20, on slide 24. DNR is to adopt NPDES permit rules for confinements that discharge. What have I said how many times today? Confinements can't discharge under Iowa law. But we are to adopt rules for NPDES permits for confinements that do discharge. I guess the point will be if they have an accidental discharge and don't correct the condition that caused it. Something along those lines. We're going to have rules. Note there, and I have a note, under Iowa law, these rules, the Iowa legislature put it in the code, these rules cannot be more strict than federal law. Because generally, Iowa law, if they want to be more strict than the federal law, we can do that. The Iowa code says, no, Iowa, you can't. Here, you can't be more strict than federal rules. And federal law says you can't be less strict. That state law can't be less strict. So guess what? These rules have to be exactly what federal law is. And I assume, Gene, that's what at one point you had told me you're waiting on a response from EPA on this. I believe what these rules will say is confinement rules for discharging are exactly the same as federal law, and they'll reference the federal rule. Makes sense to me anyway. DNR is also to revise their rules on manure application setbacks. The problem EPA sees, there's a federal rule on application setbacks, and Iowa has a rule on it. If you have an NPDES permit, of course, the federal rule controls, and Iowa law allows you to inject closer than the distance that the federal law has in their rules if you're down gradient and all that. But the federal rule also allows site-specific conservation practices, etc. Iowa has accounted for that in our rules, but federal EPA didn't think it was good enough, and Iowa will reword it. I don't believe you're going to have a problem with injecting from a confinement. Stay tuned, but I think we're still going to be okay. If you had to get an NPDES permit is where you could have the problem. Gene, you agree with what I just said? He's shaking his head yes. We're headed in the right direction here, folks. Okay. Last bullet point, DNR is to develop standard operating procedures for their inspections. Slide number 25. DNR must conduct NPDES inspections at all large and medium CAFOs by 12/31/2018. Over the next 5 years, and we're getting into the heart of the matter here, over the next 5 years, DNR must inspect all the livestock operations in Iowa, doing 20% each year. DNR estimates that the bottom point there is about 8,000 inspections, and DNR if it signs the work plan, will agree to pursue funding in the 2013 legislative session to get more staff to do this. I'll leave that one alone. Okay, slide 26. Here it is, folks. Circle this one. Here's how the inspections are supposed to take place. DNR has to give EPA an inspection plan, how they're going to do this, but the priority. This is really the heart of the matter right here. And Gene, I assume from what you're telling me, this priority order is probably not going to change. All right. First priority in DNR inspections for NPDES permits, these discharge permits, are animal feeding operations with spills or complaints. All right. That's their first priority. Number 2, large open feedlot CAFOs, so open feedlots over 1,000 animal units, and the medium-sized open lots. We're talking about these that discharge into a man-made conveyance, etc. They're next. If you have, or if your customers have, a cattle feedlot in the 300 to 999 head category, or hogs that fit into that 300 to 999 animal unit category, circle that because that's where the inspections will start. Gene, you have any idea when DNR will start these inspections? He's shaking his head side to side. Okay, Gene said that right now the work plan is still draft. They don't know when they're going to start on this, but it is really, to me, it's the first priority because spills and complaints have always been the priority for DNR. The third priority, animal feeding operations with discharges in the last 10 years. If you have a confinement operation that has had a discharge, accidental, doesn't matter, you're going to be the next priority for DNR to come and inspect, and what they'll be looking for is, have you corrected the conditions that caused the spill? And if you have customers in that situation, or if you yourself are, pay specific attention to that because you could be inspected fairly soon. Gene, I'm going to put you on the spot maybe a little bit here. In conducting these inspections for NPDES permits, for discharges, will you be contacting the producers ahead of time and saying we need to come and inspect you at a certain time? Okay, Gene. All right, Gene. All right, thank you. Gene says these inspections required by EPA will be done much like they did the MMP inspections. They'll call you and get a time set up and make an appointment. Okay? Then we come to the fourth bullet point there, and again, I've had you circle it already, but circle that one. Large CAFO confinement operations. These are the larger than 2,500 head hog buildings, or if it's a nursery, 10,000 head. This is the fourth priority for DNR. And Gene, how many do you think are in this category? Do you have any idea? No, we don't. It's a lot. And I don't think Gene can tell you when these inspections might occur. I'll go out on a limb here and say, based on these priorities, it might be unusual for those to happen in the coming year. Gene's not, he's playing poker with me. He's not giving me any indication. I don't know when that'll occur, but let's just stop here a second. What I'm telling you is that if you have a hog confinement site with more than 2,500 head, you will be inspected at some point in the next few years. DNR will call you ahead of time. They will have their standard operation procedures in place, and their inspector will come to your hog building to determine if you're discharging. Gene, do you know what you're going to be looking for yet? Okay, what Gene said was they'll walk around the buildings more than they used to, won't go inside, and they'll look for runoff. Okay? Basically it. All right, the last category are medium-sized confinement operations, and again, those would be the the MMP size sites that don't have permits, and those will be the last inspection priority. Okay, I know I'm right at it's 10:15. I don't think anybody's in the room right after us. I've got a long ways to go on some things here, and I've got really two key points I want to make. If you need to get going somewhere, I understand. I don't mean to keep you late. But the slide on animal unit capacity, I really do want to talk about because that's important. But here's slide 27. EPA has essentially told DNR you have to do a better job of documenting your penalties when a producer is in violation. They have to issue a document, basically what that producer has gained through economic benefit by not complying with the law. Okay? Gene, anything to add there? Gene, your candor is refreshing at times. At times it's not, but anyway. No, Gene is being very upfront. EPA wants higher penalties. All right? What's that mean for us? Well, be on your toes, folks. I will tell you what Iowa law provides. Iowa law provides a $10,000 penalty cap if DNR enforces the penalty. Okay? And in that $10,000, and many of their penalties are not $10,000, they will attribute it to three factors, one of which is economic benefit. EPA has told DNR you have to do a better job of calculating that economic benefit component within the up to $10,000. If a violation is referred to the Iowa Attorney General, the $10,000 cap is off. It then goes to $5,000 per day per violation. So your question might be, will we see more referrals to the Iowa Attorney General because of the cap? I don't know. We'll have to stay tuned here. I'm not going to put Gene on the spot there unless he has a comment to make. Bottom line is, I think Gene is right. We're going to see higher penalties. At least that's what EPA wants, and they're looking closely at DNR's penalty procedures. Slide 28, the last part of the work plan, quarterly reports. DNR is required to make quarterly reports, post them on the website. You'll be able to see these reports, and they have to submit annual reports. Here's this slide, slide 29, and then I'll come back to that, and then the animal unit capacity one I really do want to cover. Gene kind of covered this, but in DNR inspections of CFOs for discharges requiring an NPDES permit, I talked about, those that have had discharges, what they'll look for is, have you corrected those conditions? Let's just look at this a second. What are they going to look at a confinement operation? Okay? Everything is enclosed. They'll look at the lagoon, make sure it's not discharging if you have a lagoon, but you can't discharge under Iowa law. I think what you need to focus on there, go down 3 bullet points, feed storage. I think you need to pay careful attention to any spillage from your bulk bins. Get it cleaned up. That's just going to be something that DNR is going to have to look at and say, well, there was feed spilled. Feed storage areas are covered under the Clean Water Act. Therefore, you could have a discharge from that spilled feed. The other area, mortality composting. If you're composting your deads, those come, and you have to follow Iowa law, and Iowa law says no discharge, but pay particular attention to your composting sites. EPA mentioned that in their meeting out in Arcadia this summer. Okay? Then the real kicker is areas around the buildings. EPA has indicated in several releases over the last few years that they're looking at your exhaust fans, what do? They exhaust air, some dust. If you have a poultry building, feathers. If they see evidence of dust, feathers, or what, if you're a poultry building, if you have feathers from your hog building, you are going to cause DNR a lot. They are going to scratch their head. But they won't go in the building, so they'll never know, will they? Anyway, if there is a discharge from that exhaust fan and runoff, water, storm water carries it away and it gets into water of the U.S., EPA has indicated they believe that is a discharge under the Clean Water Act, which could require an NPDES permit. Folks, if this goes into place, there will be an uproar like you've never heard, I think, because discharging of dust occurs. Does any of that get into a water of the United States? I think, who knows, but the question is, proof of a discharge. They would have to show elevated levels of some pollutant in the water of the United States and show that that came from that discharge from your exhaust fans. I think that's going to be difficult to do. Stay tuned on this one. There was a lawsuit, where was it, West Virginia, that EPA dropped, but there was also a lawsuit in North Carolina that is still ongoing where the judge from a poultry building ruled, yes, feathers coming out of an exhaust fan that get into a water of the United States could be a discharge under the Clean Water Act and require an NPDES permit. Okay, that's one to put a big question mark by, and stay tuned. Okay, I'm going to, composting mortalities, I'm going to leave those slides to your reading. Slide 34 and 35. Again, I know I'm over my time, but I think I can wrap this up in 5 minutes or so and then take questions. This is a key component for managing confinement buildings. Animal weight capacity and animal unit capacity. You all know about this. We had animal unit capacity up until 2002. We still use it for calculating separation distances. If you expand one of those older sites, I'm not going to spend a lot of time on how to calculate that, but if you have that, make sure you're calculating that correctly. And what do we know has happened in the last years? That's happened for a long time. Slaughter weights have increased. Okay? So, if you have a certain limit on animal weight capacity, you need to be staying within those limits. And if slaughter weights have increased and you went above that, you need to talk to someone about what you should do to come into compliance. Animal unit capacity. This is what we've had in place since 2002, even for the older sites if you've expanded them for purposes of permit, etc. And here's the key. If you have a 2,400 head building, you got your MMP, your construction design statement, etc. You're all set. That's a 2,400 head building. That's what it says in your MMP. Well, you can put more pigs than 2,400 head in there. You can do that. Look at the animal unit factors. Okay? If you put more than 2,400 head in there and they weigh less than 55 pounds, they get a 0.1 factor. So you can go up to, do the math. You can go up to your animal unit capacity for a 2,400 head building. That's what, a 480 animal, or a 960, animal unit capacity building. So you can go up to that animal unit capacity with more swine than your 2,400 head at less than 55 pounds because they get a 0.1 factor. You with me? In other words, you can double stock. But when those pigs get to 55 pounds, you now have a 0.4 factor, and so you need to be down to 2,400 head once those pigs weigh 55 pounds. Gene. I'll try and repeat what Gene just said there. And what Gene, in essence, what Gene is saying, you tell me if I miss it, but there is a belief by some that the 2,400 head limit applies the day they go out the door to the slaughter, to the packing plant. No, the 2,400 limit applies when they reach 55 pounds. Okay? So, if you're over the 2,400 head, at that point, you're in violation of your limit in your MMP. What can that cause you? It can cause you some problems with separation distances to the neighbor's house. But now again, well, anyway, it can cause you problems there. And if you go over 2,500 head, then you need a permit. So all we're saying, folks, is pay particularly close attention to your animal unit capacities. And what Gene is saying, who is responsible if if you're contract feeding and you're overstocked, who's ultimately responsible to DNR? And Gene, you're saying the contract grower is, because they're the ones with the manure management plan or the permit. He's shaking his head yes. So, whoever you're feeding for, work with them to make sure that you're staying within your animal unit capacities, okay? It's a critical issue that we've talked about in past years. We needed to talk about again today. We have more inspections coming, so I think you just need to, again, be on the right page when it comes to your animal unit capacities. Okay? Anything I've missed there? Again, I wanted to make sure I covered that. Master matrix, I think in the interest of time, I'm 10 minutes over. I'll just say, Kent, I know you've worked on a lot of these. Of course, Gene, you've seen them. We've had some issues in the last year with more building going on. For those that need the master matrix because they have a permit and they're in a county that requires a master matrix, they have, we've had some issues with, basically it boils down to the design, operation, and maintenance plans. The kind of gotcha that I see there, if you need a master matrix, you can get points, and producers always take it for formed manure storage and for covered manure storage. You've got deep pit confinement buildings. You get those points. But the law requires a design, operation, and maintenance plan. And if the counties, some counties are looking closer at this, and they're denying those points and others, and then it goes to DNR to be scored, and DNR is very particular about, and they do their own scoring, your maintenance plan for a formed storage building, you might say, okay, I just keep the darn thing there and make sure the concrete's in good shape, etc. DNR wants to see a lot more detail there. So the county may approve it without that detail. If they do, you're fine. If the county denies it, even based on other points, even if they give you those points and deny it based on something else, DNR grades the whole thing over. They don't just look at what the county denied. They grade your entire test, so to speak. And DNR is very particular about those points on formed storage and covered. I'm just telling you that. I've seen a lot denied, a fair number of those denied, much to the surprise of the producer and the consultant. Okay? I've got that. Manure application, I'm going to just give a couple of points here. This stayed in place. The rule that was in place stayed in place. Manure application, liquid manure on soybeans, the EPC did not change that. Manure application on frozen or snow-covered ground, I will leave those slides to your reading. And I think, last slide I want to get to, I think again, if you have questions about anything else, let me know. Slide 45. If anything I have told you here today, you said, I got a problem. Okay? I think I'm in violation. Don't go talk to Gene. Okay? Now he's laughing. Gene knows what I'm saying. Don't go tell Gene that, because you're going to put him in a tough spot. Wait till Gene leaves. Okay? Then come talk to me or someone else, I don't care, and do an environmental audit. An environmental self-audit is where you've looked at your operation, you've audited for the legal requirements, and you've determined that you have a violation. You file what's called a self-audit. You file a notice that I have determined I have a violation, and then you tell them how you're going to correct the violation, and there will be no penalties. It's been used many times. Gene, am I accurate in saying that the DNR supports this process? He's shaking his head up and down, yes. What it does is it brings you into compliance, and that's what the DNR wants. Okay? It's a process that is supported by DNR. It's one where you have determined you have a problem. They haven't, through whatever. You've determined it, so you file a notice that tells them you've determined you have a problem, and then you correct it, and everybody's happy.